Richard.
Well, we pick up on the point raised in Stainer by Mr. Sykes, and we say the position is the same here. A dividend is a share of the company's profits paid out on a share. That's what it is, no more, no less. The company's profits are visible only from an account. They must be calculated in money. And an Antiguan company cannot pay a dividend out of unrealized profits, as we've seen, section 52(1). Necessarily, it must pay it out of realized profits, but the point doesn't need to be expressed because a dividend is a division of profits.
Are there provisions in the Act for capital maintenance and reduction of capital?
I don't have sufficient of the Act before me to take you through that.
Let me know tomorrow.
Yes, certainly. Now, the dividend in this rights purports to be just that, a dividend. And the directors, as in Stainer, purport to have exercised their right to pay a dividend as justifying, from a constitutional point of view, the entry into the rights plan. What we say is that the declaration of a dividend of so-called rights under the rights plan was not a dividend at all. It's a matter of law, it was a matter of the statutory construction of the IBCA. It didn't represent a division of profits satisfied by the way of transfer of property. Now, the company claims that the rights were property. Of course, the rights didn't exist before they were purportedly distributed, and nor were they distributed in any event in satisfaction of any division of profit. And the company says in its written case, paragraph 89, well, the property doesn't have to be property of the company. There's nothing in section 52 which says this has to be the company's property. But given that a dividend is a distribution of the company's profit, even if by a transfer of property, it must be the company's property, otherwise it's not being paid in satisfaction of the dividend. Then the company says, well, the Act says the company can pay a dividend by issuing its own shares. They're not the property of the company, so that shows that property can mean property not of the company. Well, firstly, of course, there's a specific statutory permission in relation to the payment of dividend by the issue of fully paid shares.
Can you just remind me what that provision was?
Yes, that's...
Take this to us, I'm sorry.
Section 52(1).
52(1).
And secondly, when a company pays a dividend by the issue of fully paid shares, the dividend, the share of profit that is being paid, is the payment up of that share. So there is a movement from credit to profit and loss account to capital account. That which was profit is now taken to capital, so the shareholder receives, in effect, a deferred liability in the amount of that payment. But that's authorized by the statute.
Shareholder receives a deferred liability. Sorry.
Yes, you can regard a share as a liability in this sense.
A liability of the company?
Yes, a liability.
I see. Yes.
But the short point is this is authorized by statute. And what is going on, as say, is that there is a movement from profit and loss account to capital account. That's what's going on. So there is a payment to the shareholder, simply being used to pay up the share. So for a specific purpose, to pay up the share.
That, you say, could be a use of the company's profits, but the conferring of an option is not.
No, there's simply no connection between the two. And then the company says, well, if it's not a dividend, none of this matters because the company could have issued an option to the shareholders anyway. And in a sense, that demonstrates the point. If the company could simply have issued these options to the shareholders, where is the element of profit involved in that? How is that taken from profit? In other words, it's irrelevant. The dividend aspect of this, the company says, is irrelevant because we could have done it another way. They didn't do it another way. If they had done, we would then have to investigate how the shareholder got the benefit of that option. Would it be by way of deed, for example? Would it be in some other manner? But it was done by way of dividend or purportedly by way of dividend, and it simply doesn't work. The Chief Justice and Stainer didn't grapple with that problem, and my lords, I leave that problem with you, subject to just a couple of other observations. One, of course, is that a dividend has to be declared on the shares, so necessarily the same dividend goes equally to all members of the same class of shares. What happens here, of course, is that these rights, so-called by way of dividend, explode contingently, but when they explode contingently, they operate differently between shareholders. So they become of different value to different shareholders. Now, a company couldn't declare a dividend by declaring a so-called right to shareholders that whoever was first at the annual general meeting was entitled to scoop the entire profits of the company for that year. That wouldn't be the declaration of a dividend. No more so can the company effect a lottery and say, we're giving a dividend by way of a lottery ticket, and the winner of this lottery is the one who behaves in accordance with the directors' wishes, and to them, we shall allot shares at a discount. Simply not a dividend. So it accords with common sense. It's not just a technical point. It accords with common sense as to what a dividend really is. And that takes us on to the next aspect of the case, which is sections 161 and 163, which we've looked at. And it might just be worth going back to those, if we may.
And again, Mr. Chair, just so that I'm clear in my mind, this is your paragraph 23 point,
Yes,
and you're moving to develop that. Yeah.
So if we can go back to the IDCA, 1762, the sections 161 and 163. And what can only be done by special resolution, and necessarily therefore not by the directors, it's a power reserved for the shareholders, is a need to change the designation of all or any of its shares and add, change or remove any rights, privileges, restrictions and conditions.
Sorry, which this is section 161?
Subsection E.
E, thank you.
Yes. 1762. And then...
So it's the addition of rights that you're founding on. Is that right?
Yes, the addition. So we're looking primarily, we start off by looking at the addition of rights. And then at 163(1)(c)(4), you'll see that the addition of rights can include, in particular, adding, removing, or changing prejudicially conversion privileges options.
I'm awfully sorry, just give me it's 163,
That's 1763.
1763.
1763.
Page.
Page
Oh, sorry.
163.
Page 1763.
Right.
Section 1631C4.
Right. I'm sorry if it wasn't engraved on my heart.
So 1631C4 is just an example, without prejudice to the generality, of the wording in C. And if it works for 1631C necessarily, it works for the same wording, general wording in E. So the question is, have the board attempted to do something beyond their powers within the shareholders' purview by adding something to the existing shares? So adding rights, which could include an option, to the existing shares. The distribution of rights, let's suppose for the moment that that was effective, did add to the rights attaching to the ordinary shares. If we regard the ordinary shares as a bundle of rights in the conventional way, so are the options. In the hands of the shareholders, they are a bundle of rights themselves. The company, in its written case, relies on them being rights for the purpose of its defense to our distribution argument. So here we have two bundles of rights. We've got the shares, a bundle of rights held by all the shareholders inter se, in proportion to their shareholdings. And now each shareholder is being given another, smaller or different bundle of rights in their capacity as shareholder by way of distribution on their share. They haven't acquired it in any other way, it's simply being given to them by the directors by way of distribution. And that bundle of rights, the second bundle of rights that they're given, attaches to the share. It can't be removed from it. It follows it on transfer. You can't exercise it.
Is it not assignable?
No. It's attached to the share. It's entirely attached to the share. You can't put a bit of paper between them, that right and the share, in terms of how you...
I mean, you say that as a matter of...
As a matter of the rights
construction of the rights agreement.
Construction of the rights agreement.
Sorry.
Presumably,
Yes.
we'll be looking at this rights agreement,
I was going to
we'll be
ask.
asked to construe without looking at it.
Yes, of course. We'll look at the rights agreement. Perhaps we'll go to that shortly. And then we can see how these arguments work through in respect of that. But essentially, we then have the bundle of rights. And if you have a bundle of rights and you're given an additional bundle of rights in your capacity as shareholder and in no other capacity, you haven't contracted with the company for that bundle of rights, you haven't acquired it in any other way, you've acquired it qua shareholder, it attaches to your shares, it is an addition to the rights that you have. Just as if the directors purported to give you any additional right as between the shareholders inter se. And one bears in mind that these rights only operate in effect between the shareholders inter se. Of course, the counterparty is the company which would issue any new shares if the rights are exercised, and as we'll come to see, has actually a right to exchange the rights for shares, for fully paid shares. So the company can exchange these rights for fully paid shares at some point in the future. But they are, as rights, no more or less than rights that have been added to the shares. And between themselves, the shareholders before the issue of the rights had the rights attaching to their shares. Now every single shareholder has those rights, and they have some additional rights as well. The outcome, we say, of this is entirely orthodox. The shareholders did not agree that they should, as shareholders, be entitled to exercise options to dilute each other in the event that some shareholders acted in breach of rules set by the directors. And this ultimately concerns the contract between the shareholders and the company under their as shareholders, qua shareholders. That's what it affects. It affects that contract. And what's being said is if you use this contract in particular ways, you have the right as a shareholder to or you have another shareholder has the right to exercise rights, and you won't have those rights because you have acted in this way that the directors disapprove of. Now, an alternative way of looking at this is the question of whether these rights have been changed in some way, or any conditions have been added to the exercise of these rights. In White and Bristol Aeroplane, which the company relies on, there was a question of whether the rights had been affected.
I'm so sorry, you said the question is whether conditions have been added to the exercise of these rights. Which rights are you now talking about when you say these rights?
The rights attaching to the shares. So
the original bundle?
The original bundle, yes.
Okay.
Yes. Have you changed or removed any rights and conditions? The company's answer to this is no, we haven't done that. We've only changed the exercise, the enjoyment of your rights as a shareholder. It's true that previously you had the right to vote or to buy more shares or to agree with another shareholder how you might vote. We haven't changed that. You can still agree with another shareholder how you can vote, but you will be subject to serious sanction if you do it. And all we're doing, therefore, is changing the enjoyment of your rights. We're not changing the rights themselves. Now, we say that is an unrealistic view of what has happened here. Because previously, the shareholders could exercise their rights freely. Now they can only exercise their rights subject to sanction by the company. And that isn't simply affecting the enjoyment of your rights as a shareholder. That affects the rights themselves. To be told, if you vote in this way, or if you enter into this agreement with this person, you will suffer a sanction, financial penalty, imposed on you by the directors, is just as much a change in your rights as if that had been written into the share rights themselves. And indeed, it cuts across a statutory right. I haven't shown you section 123 of the Act, page 761. Talks about pooling agreements. A written agreement between two or more shareholders of a corporation may provide that in exercising voting rights, the shares held by them will be voted as provided in the agreement. So this sanction is actually cutting across a statutory right for shareholders to enter into agreements to decide how their shares will be voted. The question of whether the company has simply affected the enjoyment of that right, as opposed to the right itself, is one that shouldn't admit of fine technical analysis so much as the reality of the situation where the section requires that changing or removing rights and restrictions and conditions requires shareholder approval. This is a condition. You could previously exercise your rights freely. Now you can exercise them, but not freely. The company itself will take steps to sanction you if you exercise the rights in the manner that you previously had. So White and Bristol Aeroplane has nothing to do with this. This is not a case of enjoyment of rights or lack of enjoyment of rights. This is a case of the rights being changed. And as we've set out in the...
So the key to what can or cannot be done is the special resolution.
Yes.
That tells you that the company cannot do this, directors can't do it. It's got to be the full shareholders. So if there's any change, amendments and so on, that's how it's got to be done.
That's right, my lord. And so the company, the board, we say, we've set this out in ground 1C of the grounds, we've said this shows, my lord's point, the distinction between the business of the corporation and those matters necessarily reserved to shareholders, and that's exactly the point that my lord has raised. And we simply say the board can't use its powers to circumvent that distinction.
Sorry, can you just remind me of the page number?
Yeah.
For ground?
Yes, 242.
Thank you.
And as we've said, the Court of Appeal should have applied that framework. The board didn't have the power. If it had prima facie power, it couldn't use that for the purpose of circumventing the distinction created by the statutory framework. Now, that subject to going to the rights agreement itself, those are my submissions on these points. So perhaps I could just show you the rights agreement. If we start the rights agreement starts at 525.
525.
Yes. And you'll see the recital. The board has authorized the company to enter this agreement, authorized and declared a dividend of one preferred share purchase right, a right, for each common share issued and outstanding at close of business on April the 8th, 2016. And then over the page at 502, there's some definitions. Acquiring person means any person who or which, together with all related persons, shall be the beneficial owner of 15% or more of the common shares. We won't go into all the detail of this, but essentially an existing owner of 15% is grandfathered in. But if they acquire any more shares, if they're an acquiring person in respect of any more shares, then they do trigger. And then 133 deals with who is the beneficial owner. 1.3, a person is deemed the beneficial owner of any securities. 131, which person or as directly or indirectly through any contract, arrangement, understanding, relationship, voting power, power to vote, directing, voting, and so forth. 133 perhaps is the closest to home here, which are beneficially owned indirectly by another person, to whom such person or any such person's related persons has an agreement, arrangement, or understanding to act together for the purpose of acquiring, holding, voting, or disposing of any securities of the company. So an understanding between shareholders as to how they will vote at a meeting is said to make that person beneficially owned in all the shares, subject to that understanding. And if that goes over 15%, which necessarily in 1Globe's case would, because it already started with over 15%, makes them an acquiring person. And then the rights are transferable at 3.1. This isn't the easiest thing to navigate. Just after the punch mark on the right-hand side, the grey punch mark, you see the rights will be transferable only in connection with the transfer of the underlying common shares. And they can be exercised under three.
This is 3.1, did you say?
Yes, 3.1. So it sets out the rights that are evidenced by, and it's extremely difficult to navigate.
Yes.
But essentially, when a person becomes an acquiring person, which is the distribution date, then those rights can be exercised. And you'll see that at section 7, the exercise of rights. Registered holder of any right certificate and exercise the right, in whole or in part, at any time after the distribution date, upon surrender of the right certificate. And then the mechanics of that is set out, and they can purchase the shares initially for $30. And there are all sorts of adjustment mechanisms which we need to be concerned with. The other thing just to mention, though, is as well as that, there is a provision for the directors to exchange the shares, and this is at 560.
Just before you go, I see the 7.2 is the purchase price.
Yes.
I see. So the registered holder of the right certificate, which you say must necessarily be the shareholder, a shareholder, can exercise the rights at any time after the distribution date upon surrender of the right certificate, and presumably with payment of the subscription
Yes,
money.
with payment of the subscription money. But the right is cancelled in respect to the acquiring person. The acquiring person doesn't have that right.
No, I appreciate that. I just want to understand the mechanics of how a right becomes a share.
Yes, they will subscribe for the shares, one way in which it can happen. And I'm going to show you, my lord, another way in which it can happen.
All right. But just, sorry, the price for each 1,000th of a Series A preferred share is initially $30. So what happens? I mean, you're a shareholder, you've got 100 shares, and then you get this right. I mean,
Yes.
but it may not matter, but it just seems that...
I hope it doesn't matter.
Oh, let's pass
one
it.
then goes through from those preferred shares
okay.
into common stock. But what I wanted to show you was something which I think is more relevant perhaps to the events that have happened, which is the exchange provisions at section 27.
That's on page...
At page 560.
Hold on.
So that's we looked at it from the shareholders' point of view, that they have that right. But at section 27 exchange, 27.1, the events, the board may at its option at any time after the occurrence of a trigger event exchange common shares for all or parts of their then outstanding and exercisable rights, which will not include rights that have become void pursuant to 11.1.2, that's for the acquiring person. Exchange ratio of 1 right common share per right, appropriately adjusted. So for every share you get 1 right. After a trigger event, the board can exchange that right for another share, another common share. So you'd have 1 share, you now have 2 shares, so it doubles the number of shares that you have.
So this seems to give the board the right of initiative to make that happen.
Yes.
And the previous provision seemed to give the initiative to the holder of the certificate.
So they had an option there. And here, the board has the right to exchange the right, if you like, for another share. And at the end of that provision, there's some, don't need to, deal with that. But you can see there's a one-to-one, so you get your shares doubled unless you're an acquiring person. But then at the end of 271, it says that, the last 4 lines, any common share issued at the direction of the board in connection herewith shall be validly issued, fully paid, and non-assessable common share. Company shall be deemed to have received as consideration for such issuance a benefit having a value that's at least equal to the aggregate par value of the share to be issued. So
the shares do have a par value,
yes.
Shares. And the company is deemed to receive, but that would have to be a transfer from P&L account to capital, wouldn't it?
Yes.
Because it's not, I mean, the shareholder doesn't actually have to pay anything.
No, the shareholder doesn't have to pay anything.
But they do have to be paid up as to par,
yes.
Which can only be effected through capitalisation of profits.
Which could only be done equally between all the shareholders.
Well, all with who are assigned one of these common shares.
Well, no, with respect, my lord, all shareholders, because you've got to pay up those shares out of profits. So that means you need to have a distribution, and that is in right, and all the shareholders are entitled to that, unless it is the case that this has varied the rights of the shareholders, of all the shareholders, to say some of you will get a distribution, in other words, a fully paid share by way of distribution, and some of you won't.
So, in a sense, is the point this, you say, well, where is the power in the directors to issue bonus shares to some, but not all, the holders of,
yes, let's
say, the ordinary shares?
I think that's right.
You've got to look for a power in the articles to enable them to do that, you'd say.
Yes. As Chief Justice Atwood accepted in Stainer, the onus was on the board to show that they had that power.
This hasn't been done, has it? I mean, in this case, has Section 27(1) actually been exercised?
Yes.
It has?
It's subject to injunction. That's
what do you mean? Sorry.
It has been exercised, but you saw the ruling of Judge Laster, where he injuncted the board from continuing with that process. The board's resolved to do it.
But had they actually issued the shares? Have they made the entries in the share register?
I believe they haven't. I believe they've been injuncted from doing that.
From doing that?
They've resolved to do it. The board has resolved to do it.
And when was that done? Do we know? When?
That was done in March 2019.
So the shares were not issued on February the 6th, 2019, the date of the AGM?
No.
So they couldn't have been voted at the AGM because they hadn't been issued?
You and I would agree with that, no?
I'm just wondering whether that's the case.
The company took a different view.
I see. We'll hear about that, no doubt.
And that's going to be resolved, if at all, in Delaware.
That's right.
Yes.
Yes.
Well, I mean, that's an interesting point because it's how this agreement interlocks with the constitution of the company, and the constitution of the company is a matter of Antiguan law, not Delaware law. I mean, if the agreement cannot be given effect in accordance with the constitution, then it's of no effect.
No, and that was exactly why Vice Chancellor Laster expressed his exasperation that this matter was being thrown back to him.
Yes.
He took the view, but it may not even be effective at all if you try and impose a Delaware law into the Constitution.
But the resolution in March was to issue the rights to subscribe, presumably.
No, the resolution in 2019, March 2019, was to exchange the shares.
Pursuant to this section 27.1.
Yes.
Or to exchange the rights for shares?
Yes.
Right.
Yes.
But that involves the issue of shares.
Yes.
And the transfer of money that we talked about between the accounts.
You don't have to pay, do they?
No, because
it's under 27.1, there's no payment required.
Yes, it would have to be paid.
Is that right?
nominal value of the shares from the PL.
Oh, yes,
That's what I meant.
yes, no payment by the, no actual payment
No
to the
payment by
company.
the subscriber.
No payment by the subscriber, so
Just be a bookend.
that's the point. There's no payment by the subscriber.
Yeah.
Yes, I see.
So those are the provisions that I want to show. It's a complex agreement, and there's a lot to it. But for the purpose of these arguments, I think that is sufficient. Perhaps just one other thing. Section 27(3) of the agreement, before we move on from it, I'm sorry. While we're on paragraph 27, (3) explains what happens if there aren't enough shares. Then the company can issue other equity securities of the company, debt securities of the company, in each case having an aggregate value equal to the current per share market price of one common share. And if then there aren't enough common shares, the company can pay cash equivalent to the market price. So 2 is cash. It can pay cash or other equity securities. So in other words, if the company can't, because there aren't sufficient shares, issue these shares, then instead it just gives cash or money equivalent to the market value of shares, not the nominal value of the shares.
So I'm trying just to find where that is. As you say, this is a pretty dense provision.
Yes, 27(3).
Yes.
The company may at its option substitute for each common share that would otherwise be issuable upon exchange of the right a number of shares or fraction of them, cash, other equity securities of the company, debt securities of the company, or other assets, in each case having an aggregate value equal to the current per share market price of every common share. So if you haven't got enough issued share capital, and bearing in mind you're doubling the shares of everyone other than the acquiring shareholder, if that means that you've reached the headroom for capital, just give them some money. You give those shareholders some money instead, some assets of the company. You give them cash, not equal to the nominal value of the share that they would get, but the market value of the common share that they would get. So some shareholders...
So if this provision were triggered, then it does have an effect on the company as opposed to the shareholders, because the company is having to shell out cash or other assets.
Yes, absolutely.
So, yes, I see. Right.
So, with that, may I move on to the annual general meeting round? And we've been through the provisions of the Act. Shareholders have the right to vote by in person or by proxy, move directors and so forth. We've been through the bylaws, which mirror the Act, essentially. We've looked at the notice requirements at an AGM, and in respect of the election of directors, there are none. And we've looked at 122.
Sorry, look at what?
Sorry.
I just didn't hear that sentence.
Section 122.
Section 122. Right. We looked at that. I just don't want to go over the ground. And what happened in this case was, notice was given for the AGM. We needn't turn it up, but it's at tab 7, PDF 164 of your bundle, page 164. That notice identified the re-election of the existing board, although as one has seen from the Constitution and the Act, it didn't need to do that. And then the judge below at paragraph 21, page 20 of his judgment, he refers to paragraphs 21 and 27.
We have an electronic page number.
Perhaps if we deal with this at 21 first, referring to the Betts principle, which we'll come back to, says halfway down, there appears to be nothing in the IBCA, the IBC regulations, the bylaws of the company, or its articles that prohibit or restrict the proposing of amendments to resolutions or motions at an AGM. And then paragraph 27 is the point where he deals with the statute, with the IBCA. He says there's nothing in the IBCA or regulations prohibits an amendment to an ordinary resolution. He says, business of election of directors is an ordinary motion or resolution carried by a simple majority of the votes cast. And he refers to the bylaws, paragraph 28. They make clear the election of directors at the AGM was not special business. As an ordinary resolution could have been passed by a majority of votes. That's something of a non sequitur, and he refers to ordinary business. It seems he's confusing ordinary resolution with special resolution. And then he says it doesn't appear there are any technical breaches, if I might put it like that, of Antiguan law in proposing the amendments to the motion at the AGM. Matter cannot, however, be analysed in isolation from the court's earlier finding that the shareholders as a whole were entitled to full and fair disclosure, and that's what we have to address. Now, if we look at Betts, which was dealt with by the judge, it was put before him as ground for saying that the amendment to the special resolution, the amendment to the resolution to elect the ordinary, the incumbent board was good. Betts was cited to the judge to show that that was permissible, and there were no grounds for saying that the directors weren't removed and the new slate re-elected, the new slate elected. Betts was a decision of Miss Justice Eve in 1909, and you'll see from the head note,
Wait, can you give us a
page number?
3182. That there was a notice of an annual general meeting, passing the resolutions with such amendments, alterations determined upon. One of the resolutions was that 3 named gentlemen should be appointed directors. They were proposed as directors. An amendment was, however, carried in addition to these 3 gentlemen, 2 additional named directors could be appointed. And then, if you look at the articles of the company, 3184, there was provision for giving notice of meetings. If the meeting is an extraordinary or ordinary meeting in which special business is to be transacted, then specifying likewise the general nature of the special business for which the meeting is convened or which is proposed to be transacted. Article 55, all business shall be deemed special that's transacted at an extraordinary general meeting, all that's transacted at an ordinary meeting with the exception of sanctioning a dividend, consideration of the accounts and the ordinary reports. It's worth just noting that in BETS, the election of directors was special business, in respect of which notice did have to be given. It was not ordinary business, as we have now. And Mr. Justice Eve at 435, so page 3187, and just above, about a third of the way down, he asked, was the business transacted at the meeting within the scope of the special business indicated in the notice? In convening a meeting which special business was to be transacted, the company were under no obligation to state the terms of the specific resolutions. Under the articles, all that was incumbent was to specify the general nature of the special business. Although on this occasion the conveners went out of their way to indicate with particularity the mode in which the special business was to be submitted, their having done so cannot impose any greater restrictions on the meeting than would have been imposed upon it had the notice been in more general terms. Therefore, regard this notice indicating the general nature of the special business and further the particular form in which that business was to be submitted to the meeting. Special business was the election of directors. Ought I to hold the amendment which purported to reappoint the 3 gentlemen and to add 2 other gentlemen as additional directors was so inconsistent with the object of the meeting, so irregular to be beyond the power of the meeting? Was it, in short, an amendment no reasonable man would have regarded as competent to be put forward at a meeting so convened? This connection must be borne in mind. Minimum number of directors was 3. If, as was possible, any one or more of the individuals named failed to be re-elected, a fresh name or names would have to be submitted. I think I must assume the shareholders who received this notice were alive to this contingency, further aware that in the matter of electing directors, the only restriction on the power of the company is to be found in the article which limits the maximum number to 7. A reasonable man reading this notice must have apprehended those present at the meeting would regard themselves as empowered to make such appointments to the board as they thought fit, so long as they did not do anything contrary to the regulations. No one could have thought the meeting was convened to appoint the 3 named individuals without the power to substitute other qualified persons for all or any of such individuals. Nothing to indicate the company will not exercise the power of increasing the number of directors under 83.
And can I just ask, where it says, if any of the 1 or more 3 individuals named in the notice fail to be re-elected, a fresh name or names would have to be submitted for appointment. Is that because the articles required a certain number of directors?
Yes. Right, that was because in that case there was a minimum of 3 directors.
Right, okay.
The company in its written case has said, well, here there's only a minimum of 1 director, and they'll seek to draw a distinction on that basis. But of course, even with 1 director, it must be implicit that if you remove all of the directors that are up for re-election, it must be implicit, even on, if I can put it, the narrow basis, that at least 1 person is going to have to be proposed in their stead. Now, what the learned judge, so BETS is a case that concerns special business. Our case, of course, concerns ordinary business. And before going to see how the learned judge dealt with BETS, it's just worth putting down these points. The notice of the AGM was itself, under the rules, under the Act and under the bylaws, sufficient notice of the election of directors, regardless of the removal of any director. A resolution put from the floor to appoint X as a director would have been a good resolution because it was expressly ordinary business at an AGM for which notice had already been given. So there was no requirement for any further notice at all. Now, an amendment to a resolution could not be out of order if the resolution as amended fell within the existing notice. That's effectively BETS. But the election of the directors in this case did fall within the notice, because the notice of the AGM under the statute and under the bylaws was itself notice of the election of directors. So the fact that a specific resolution had been proposed unnecessarily in the AGM notice, because that was already business of the meeting.
Well, it's a slightly loaded way of putting it. It wasn't a notice of election of directors, was it? It was simply a notice of an AGM. All it had to be was just a notice of an AGM.
Exactly.
Which covered any ordinary business that an AGM could transact.
Yes.
I mean, in fact, it went further in this case, but it notified, didn't it, the re-election of directors.
The notice went further.
That's mere icing on the cake.
Fine.
Can we look at the notice?
Yes, we can. The notice is at page 164.
164. I think you gave us that before, and I couldn't find it there.
Yes, I've turned it up. I think it's a wrong reference.
No.
Oh.
I think 164 is in skeleton arguments or something like that, or judgments or something. I think we've...
Sorry? 686, I'm told.
Right. I think that looks like it, yes. So it's...
Yes. Notice of annual general meeting.
Actually, it's sort of 687. We actually get the notice, I think.
Yes.
Yes, I think that's right. The pack, if one likes,
Yeah.
starts at 685. We then have the notice at 686. We're holding the annual general meeting for the following purposes. And then the re-elections are set out, approving the audited statements and approving the appointment of the auditors.
Well, the key words are the annual meeting will also transact any other business as may properly come before it, or any adjournments or postponements of the actual general meeting.
Yes.
Because the business of which they give express notice isn't the bit you need.
No. No, we don't need anything other than this is the annual general meeting. We're holding it, because that imports with it all the ordinary business that the Act says can be conducted and the bylaws say can be conducted at that meeting.
But for the with also transact rubric, I suppose it might be argued that if you choose to limit the business at an AGM by giving a notice you're only going to transact certain business, you may have trouble in just getting other ordinary business in.
Well, it wouldn't be notice of an AGM. The directors don't have power to limit the business that can be conducted at an AGM. It's a statutory provision and the provision of the bylaws. You can see, incidentally, that at 689, when we come to it, there is a provision for voting by proxy. And there's reference to voting by proxy, and there's reference to an online service, the Broadridge Investor Communication Services online program.
Where is that?
It's at 689 under voting by proxy, and the reference in the middle. So it's saying, well, you can deliver a paper proxy back to us, or you can use the online service by Broadridge.
I mean, this... Well, I'll ask it now, because you make the point in your written case that there was no ability to vote online before the meeting. Shareholders could attend in person or by proxy. Of course, you appointed a proxy in advance of the meeting, but it was the proxy who voted at the meeting.
Yes.
So when it says here, this programme provides eligible shareholders who receive a paper copy of the proxy statement the opportunity to vote via the internet or by telephone. Does that mean at the meeting? Or is that actually a slightly garbled way of putting it?
My Lord, I'm not in a position to answer that because I don't know.
No, okay. Your position is that there was no voting before the meeting. The votes were cast either by shareholders in person or their representatives if they were a company, or by proxy.
Yes.
In the conventional way.
Yes. Well, not only that, but there is no provision for voting before the meeting.
No.
But I'll come on to the evidence, if I may, as to what
Yes.
actually happened. But it's worth perhaps just looking at what the judge said about bets, first of all. Now, we'll see that at paragraph 21 of his judgment, where he deals with bets. And then he says, I think, however, the instant case is materially distinguishable from bets for the following reasons. In bets, 2 additional directors were nominated in addition to the 3 proposed for nomination. In the instant case, the proposed amendment was for the replacement of the proposed nominees, except for 1. Well, that's a curious attempt to distinguish it, because, of course, the judge in bets, was Justice Eve, found that the 2 additional ones could be appointed, because necessarily the others could be removed, and therefore you might have replacements. So that certainly wasn't a material distinction. In bets, the proposed amendment for 2 additional nominees was within the Articles of Association, which limited the board to a maximum of 7. In the instant case, the dissenting shareholders proposed a cap on the number of elected directors that was below the 15-member limit prescribed in the Articles of Association. But it's not suggested that in the instant case the result of the board elections would be to exceed either the cap as originally set or the cap as proposed. Simply not clear what relevance that can possibly have to the question. 3, bets in a 1910 case was in a different era. The internet had not yet been invented, and so the concept and possibility of voting online in advance of the AGM did not exist. The instant case involves a company with multinational investors and regulated by US securities law, whose shareholders routinely voted online in advance of an AGM, and therefore had no notion an entirely different slate from that for which they voted would have materialized at the AGM. Now,
so he does seem to think that factually shareholders routinely vote online in advance.
yes, that's what he seems to think.
I mean, is that demonstrated by evidence to be incorrect in this case?
I'll show you the evidence that I have found about voting online.
We would want evidence that it was permitted, I think.
Yes, I'll show you that evidence if I may, but just...
But in a nutshell, what is the answer to the question?
Yes.
The answer to the question is at bundle 1, page 335.
I'm sorry, I missed the page.
335.
Thank you.
And this is the company's evidence dealing with the AGM. 335, paragraph 21. The AGM notice contained detailed guidance on the appointment of proxies and voting requirements. Guidance explained votes could be voted online by proxy, or at the AGM itself by the shareholder or their legal proxy.
That's an attempt to summarise the AGM notice.
It's an attempt, but it's voting online by proxy. In other words, it suggests that proxies are involved.
I mean, that's a very odd way of putting it. The guidance explained that votes could be voted online by proxy. I mean, I don't really understand what that means.
It's difficult, but if...
I mean, presumably, how you vote at a general meeting is a matter which is governed either by the statutory provisions or by the articles and bylaws. So
yes.
What do they say about it? Do they make provision for any of those make provision for online voting ahead of the meeting?
No, they don't. They say that voting shall be in person or by proxy.
Is that in the Act or in the bylaws?
Both.
Sorry?
Both, I believe.
I mean, it might be useful to have
Yes,
that.
I'd hope we'd gone through this, but
I'm
this
not
wasn't
sure.
in your mind at the time. So we'll go back to that, if we may.
But we've got the AGM notice, so this paragraph doesn't
really.
either is or isn't an accurate summary of the AGM.
It either is or isn't summary
I've
of that.
miswritten down the page number of the AGM notice, I'm so sorry. Just been trying to get back to
The
it.
AGM notice
687, I think.
687.
687.
But
So the provisions of the Act dealing with this are that Section 28A of the IBCA
We've looked at that one.
I'm just on 687. What you apparently
that
could do
doesn't
is
tell
to
us.
submit your proxy over the internet.
Yes.
well, that's,
Yes.
Doesn't tell us in advance or not.
No.
Yeah, but if you have a paper proxy, you can send it in advance of the of a general meeting of the company.
My lord, you have to send it in
Yes,
advance.
precisely. So, I mean, does online proxy mean any more than you're submitting your proxy form online?
And this is where the judge fell into error.
right.
It's absolutely. So one sees the provisions of the Act at paragraph, section 28A.
Yeah, it doesn't quite cover it.
Sorry, that doesn't quite cover it.
Which is page?
1748.
That's just the general right to vote.
That's the general right. Can I take you in the meantime to I think this may be passed it on to the model, if I can come to that, but we do have the bylaws that provide for this.
Right.
And
Can just so that we have it in our minds, can you summarise, although you're going to provide the statutory provision, does the statute allow voting in advance of the AGM
no,
online? No.
no, it doesn't. And the bylaws provide at 710, it's at page 518, that votes may be given either personally or by proxy. And then it sets out that the instrument appointing a proxy shall be in writing under the hand of the appointor. Proxy need not be a shareholder.
Yes, I see.
So you have to have a written...
That's what you took us to before.
Yes, absolutely.
Yes.
But you could email a proxy or send it online
Yes,
Yeah.
to your proxy,
yes,
and he could produce that as his valid proxy for your vote at the meeting,
that's right,
if he attended personally.
that's right.
Yeah.
So the position is, quite simply, that the learned judge was wrong to be concerned as regard or to distinguish bets on the basis of the modern practice of voting online. It certainly wasn't applicable in this case, because there is no provision for voting online. So what one is left with is actually the same era as bets, which is that, as is in the case for pretty well the life of companies, certainly in England and Wales, votes can be given by person or by proxy. The proxies have to go in advance of the meeting. And necessarily, therefore, any business that is raised on the floor of the meeting, of which notice doesn't have to be given beyond the notice of the meeting itself, can be dealt with by those persons in present or those who are there by proxy. The thing about a proxy, of course, you are at the meeting by proxy. The member is at the meeting.
Yeah.
And the fact that proxy forms have to be lodged prior to the meeting it is no bar to the raising of ordinary business. Now, what was slightly ironic that
Sorry, can I just check?
Yes.
Presumably a proxy form could limit how someone should exercise the vote, but it might be general. In other words, you go and be my representative.
Yes, it could. And issues do sometimes arise as to how a proxy should exercise their discretion in circumstances where a new item of business comes up that has, such as an amendment. So there are cases that do discuss what happens when there is an amendment to a resolution, how a proxy will vote. But that's a matter between the proxy and the shareholder.
And I think you did show us the proxy form attached to the notice of the AGM. And I've now forgotten, is that just a general proxy?
I don't think he did show us.
Oh, I'm sorry. I thought,
No, I didn't.
no, you didn't. Okay, you should just.
I didn't take you to that.
Do we have the relevant proxy forms that were sent out, or?
We do have the proxy forms, and we can make a note of where they are and let you have those. 698. I'm obliged to my learned friend.
Thank you. Oh, gosh.
Now, this is this rather bizarre proxy form that allows shareholders to tell the proxy that they can vote for and against resolutions 2 and 3, but when it comes to re-election of the directors, the option of voting against is not included.
Yes.
I mean, that can't prevent a proxy voting against a resolution.
No, this was raised in correspondence with the company, and I think there was a letter referred to at 982, page 982.
I'm sure about 982.
Redacted. I have a question for you. Is withholding the same as voting against?
Yes. Dear shareholder, thank you for your inquiry.
Have the right to vote. They have the right to withhold their votes as well as vote for another candidate. Oh, that's quite interesting.
It is, my lord, yes. I was going to come to that later, but it is quite interesting, isn't it?
Yeah.
I think the way that the meeting was conducted, and it is the way that sometimes these meetings are conducted, is that the votes for a resolution are counted, and if those constitute an absolute majority of all the voters present at the meeting, then it's passed. So the withheld in that circumstance is the same as the vote against. Because those who voted
Oh, I see. Well, that's a bit odd.
it doesn't count abstentions. You'd have to knock out abstentions as well.
But if
I think that's how the company was doing it. I agree, it's a bit
it's
odd.
very odd.
Yes. Yes, it's very odd.
Well, I mean, if withheld is treated as voted against, then that's fine. But otherwise, it's a bit odd.
Yes.
But be that as it may, you don't have to use the form of proxy which the company gives you.
No.
No.
No, you don't. So the learned judge then imposed this apparent overlay, this distinguishing bets, at a time actually when communications are easier than ever because of the internet. They haven't got more difficult. It's now you can get hold of your principal at any time, anywhere in the world. Actually, if you're a proxy holder and you say, I want to know what your instruction is on this, it's easier than it was in the days of bet in 1909.
Yes, but if the meeting's already started before anybody knows that an alternative slate is going to be proposed, you might find that your proxy doesn't pick up the mobile phone and answer your desperate...
Your principal, my lord, your principal. You are the proxy.
Sorry, the other way around, yes, but I'm thinking of...
Yes,
I mean,
you might, in which case, no doubt, you can vote in accordance with the proxy. And if that proxy is to vote for the current board, you vote for them and you vote against the amendment.
Yes.
That's simply how it works. You're present at the meeting. So then we go to this idea that if shareholders had no notion that the slate might be appointed at the AGM, well, that simply reflects their lack of understanding of the rules by which they were bound. Nothing more than ignorance on their part, because a shareholder who chose not to attend the AGM, in person or by proxy, must be taken, because the statute and the bylaws so provide, to have accepted that any lawful business might be conducted in their absence. As the judge accepted, paragraph 28, there were no breaches of Antiguan law, but he tried to impose a new law. And at paragraph 23, he says this: where the company's articles of association and the governing law are silent as to how one might reconcile online voting in advance of an AGM with the right to move an amendment to a motion at the AGM, the best that the court can do is insist on a minimum standard of basic fairness. So his whole premise is wrong as a starting point. Those shareholders who voted online in advance of the AGM were following a routine practice, voting for one slate that had been re-elected for many years, had no reason or warning to expect anything different, and no idea a different slate would have been proposed. They, as well as those...
In a sense, they don't really matter.
No.
Because they voted for the existing board anyway. The ones who matter are those who chose not to vote.
Oh, exactly. I mean,
which the judge then does deal with.
Yes. Absolutely.
But he's wrong. The next sentence, they, as well as those who chose not to vote, did not have an opportunity to make an informed decision. That only is relevant in the sense that those who had lodged a proxy beforehand in directing the proxy to vote in favour of the re-election of the existing directors were deprived of the opportunity of voting for the dissidents' slate. But that's not a point that's really raised in this case.
Quite. My lords have the... Yeah. So then he says, the dissenting shareholders planning in secret to propose an alternative slate, no good reason for not giving advance notice. This undermines basic fairness to which the shareholders as a whole were entitled. Now, that is to put an entirely new overlay on the concept of giving notice and the bargain between the shareholders. Because so far as online voting is concerned, as my lord pointed out, it can't make any difference to those who are present at the meeting. Indeed, the only thing it could do could be to disadvantage the alternative slate, because they might not get support they otherwise might have got at the meeting. So far as the online voters are concerned, the non-voters are concerned, it's irrelevant at all. It's not an online voting issue. It's a notice issue. It's purely a notice issue. Did they have notice of a meeting at which these directors, the incumbent board, might be kicked out and new directors might be put in? And the answer is yes. They had notice and they chose not to attend. So then the judge says, well, to the extent that he says that the slate had never bored the incumbent board. No one had ever opposed them before. No one expected this to happen. Now, if that were to be relevant, one would have to show that there was some expectation in the form of some equitable restraint. Fairness in the context of companies doesn't mean something that the judge happens to think is a bit offside at the time. The question is, what was the bargain between the shareholders? And the bargain between the shareholders was that any shareholder could turn up at the general meeting, having decided 3 weeks in advance that they were going to vote against the director, and they didn't need to tell anyone that they'd made that decision. And if it be the case that they had an understanding with some other shareholder how they would vote, they could both turn up at the general meeting and vote against that director. And there is no unfairness in them doing so, because they had not entered into any bargain with any other shareholder. It's not suggested that they had somehow given away the right to do that because of their own dealing in the past, their own conduct. This is a list of companies. Shareholders are coming in and coming out. How is it said that some sort of obligation or expectation arises to which the court will have regard? As it happens, the learned judge failed to take into account in any event the clear red flags that were present in this case. In the first place, since the last AGM, the company had been the subject of a public takeover battle. And the management consortium, in other words, including the directors, had been chosen by the directors as the preferred, indeed the only permitted bidder, at a price lower than the rival's offer. They had offered $7 a share, the rival had offered $8 a share, and the board decided to go with $7 a share. And they announced this. They announced that they were going ahead with that transaction shortly prior to the AGM. A public announcement of their filings with the SEC. So this was the last AGM. This was the last opportunity for any shareholders to deal with this fact that the board was going with the preferred bidder at the lower price. So that might have been a red flag that might have alerted shareholders who actually cared about that. This is the last chance we're going to get to deal with this issue. And the company was also aware, because it was told, and it was publicly available information, that the rival bidder was actually calling for the removal of the incumbent board. A pretty big red flag when it comes to saying, well, no one thought, we thought that we were just going to have a cup of tea and go home.
And sorry, where's the evidence on that?
That was the press release of the rival.
The Sinovac Biotech press release.
Yes.
And the bundle reference?
Bundle reference to that. $971, my lord.
79, thank you.
971.
Oh, 71.
971. We won't take time on it now, but please have a look at it. It's a pretty punchy document, and again, doesn't suggest that. I should say it wasn't issued by a shareholder. Sinovac Biotech wasn't a shareholder in the company.
No, it was the bidder.
It was the bidder. It was a shareholder in a subsidiary, in an indirect subsidiary, but it wasn't
That's probably neither here nor there. It was the competing bidder.
It was the competing bidder. So it was urging people to vote down the existing board.
But I mean, your basic point lies in the phrase "no good reason for not giving advance notice," contains an assumption that they should have, unsupported by the bargain between the parties.
Right.
Yeah.
Oh, that's right.
Or by the Act.
Or by the Act, exactly. So then, just dealing very briefly with the authorities on which my learned friends rely about giving notice of meeting, notice of business. They've set out a number of them: Pacific Coast Coal Mines, Gorman Long, Kay and Croydon Tramways, Heaton and Henderson. They've Moorgate Mercantile. They've even got a vote for a quote from Council Service. I should say something about that, perhaps, since it's a section of the text for which I'm responsible. But all of these cases concern the adequacy of notice given for the business to be conducted at the meeting. Ultimately, that's what they all come down to. But as we've seen, the Act in section 109 requires notice to be given, which is itself, in the case of special business, adequate notice, if I can put it that way. And the Act says, well, if it's ordinary business, there's no notice at all. So the question of what notice It's a particularity of the notice that you have to give in respect of any resolution is answered by the Act, and by the bylaws. And it's impossible to extrapolate from the cases where notice has to be given some rule by a side rule that in a case where notice doesn't have to be given, nonetheless, you have to give some sort of advance warning of your intention to move that business. And the company then relies on CLUAC, which is a Bundle 5, Authority number 34.
Page, I'm sorry.
That's at page 2739.
Thank you.
This was the case that the judge relied on below. It's a 1-2-2 case. It arrived at the fight to control the directors of the respondent company, and the applicant spearheaded the dissident shareholders. And both the company and the dissident shareholders sent out proxy circulars to the shareholders, saying why they should vote for them. And at 12, page 2740, the reference is made to the dissident circular, and the content of that is set out. 12, we need to be concerned with the content. This goes to all shareholders. 14, was it misleading? Is the next section. Author of shareholder remedies makes the comment, case law requires that all information be disclosed. A reasonable investor would consider important in deciding whether to vote. Goes to dormant law. Dormant law refers to how many people are present by proxy. Essentially explanatory circulars sent out by the board of the company, perfectly fair, give all information reasonably necessary to enable the recipients to determine how to vote. Then he says, what is true for a board circular is equally applicable to a dissident information circular. Shareholders must have all the information they need in order to make an informed decision about voting. Now, this is what the judge below picks up on. But 17 says, the issue then is whether the dissident proxy circular was materially misleading in the sense it deprived shareholders of sufficient information to form a reasoned and informed judgment. In my view, it was. What can I say about this? Firstly, this is a case where a shareholder circulated a misleading statement. You can't draw from that any principle that a shareholder is required to give notice of a resolution for which notice is not otherwise required. Second, if it's looked at in terms of fairness, then the case might be justified on its facts. While a shareholder owes no duty to say anything at all, if they do say something, it might be said that they have a duty not to mislead. But silence isn't misleading unless there's a duty to speak. Here, the bargain between the shareholders is there is no duty. The judge took no account of that bargain. Third, it's notable that the court in CLUAC did grant relief to the claimant, namely a further meeting. And the judge below didn't explain how the balance of justice required him to refuse any relief, when the only possible relevant question, even if some notice of 1Globe's intentions should have been given contrary to our, was how the unrepresented shareholders might have voted. So it could have been determined with a lesser interference with the rights of those who did vote. The judge didn't give weight to that, the loss of those rights. And he didn't even give the unrepresented share, he wrongly characterized as disenfranchised, which was a clear error, an opportunity to have a say at all. Well, it may be that that's a convenient moment before I was going to move on to section 71.2
Well, that seems to be, given the scope of the appeal now, I take it that if we have a full day tomorrow, that won't cause trouble. We were proposing, because we have to rise now, that we would sit at 10 o'clock tomorrow morning. I note from the timetable and the programme, of which I was unfamiliar, that it envisages a break between 12:30 and 1. I would suggest that we sit from 10 till 1, with maybe a short comfort break in the mid-morning for 5 minutes, and then I'll then sit 2 to 4. Would that suit parties? I think that should provide adequate time for completion of submissions. But if you wish to allocate that time between you and give a note to the board as to how you wish to allocate that time, then that will be fine.
Well, we'll do that. We'll discuss that between ourselves. Thank you very much.
I'm very grateful. The board will now adjourn.